Let's give you a live look now at Capitol Hill this morning in Washington. Today, U.S. Supreme Court justices are hearing a challenge to a DEI ruling. The court will hear Ames versus Ohio Department of Youth Services, its first employment discrimination case since President Trump took power and began making changes to DEI around the country. The case concerns whether members of a majority group, such as white employees, must face a higher evidentiary burden when proving a workplace discrimination claim. This comes after Marlene Ames sued the state's youth correction system after it failed to promote her back in 2019. She alleged, among other things, that in addition to her race, her sexual orientation factored as well into her demotion. She lost 2 jobs to gay candidates she asserted were less qualified and noted that her supervisor was also gay. Joining us now, our chief legal analyst, Khalif Rhodes. Okay, a lot to unpack here with this. Let's first talk about reverse discrimination, kind of what that means. Sometimes we don't talk about it very often.
Yeah, I mean, you see that a lot. I mean, specifically when affirmative action cases pushing schools to change their admission policies. A number of people that were bringing these cases were Caucasian individuals that were saying the policies that were put in place were actually anti and reverse discriminatory towards them, while the courts were trying to make efforts to stop discrimination towards one class or one race or one sex. On the negative effect, the secondary effect that they were making the argument is that it also is now discriminating against me as a majority, as a white male. And so those cases probably sparked in the 70s, in the 80s. And now you're seeing it a lot more, not just in academia, but you're seeing it in the workplace. And that's where you have these these 1964 type of challenges, these civil rights type of challenges that are all based on that same argument that while we can understand and appreciate what you're attempting to do, I am now also being discriminated, and because I'm being discriminated against, now you're violating a number of constitutional privileges that I should be entitled to, and I want my due process.
Okay, so this lady is claiming that she did not get a promotion, basing it 1 on that she is Caucasian and 2 that she's heterosexual and was passed over for those that are gay. What type of evidence do you have to have for this to be able to go forward in your favor?
Jason, every time you take me back to law school, I love it. So this is the court. Let's talk what the courts have done. The lower courts on the trial court level, the Court of Appeals, the 6th Circuit, they all dismissed and ruled against Ames's claim. And the Court of Appeals basically said that a person needs to show these background circumstances. So if I have a traditional discrimination case where it's a majority discriminating against a minority, that analysis is not required. And emphasis on analysis, because that's a key part of the argument. What Ames is saying is that this is not an analysis. This is a heightened requirement. You're saying that not only do I need to be discriminated against, I also have to show all these extra hurdles that that was called background circumstances. The courts, both the lower court and the Court of Appeals, said no. This isn't an additional hurdle. This isn't an additional standard. This is our analysis. We're saying that in addition to being discriminated against, how we view your discrimination has to be viewed through these lenses. Specifically, can you point to a history of this company doing that? Is the minority discriminated against the majority on a consistent basis? And the court in this case says no, that the only thing that she could point to was her own case. One of the other things they want you to say is that was the majority, I should say the minority, the only people making the decisions when discriminating against the majority. And in this case, they say no. While there were gay folks on the panel that made the determination, there were also heterosexuals on the panel that made the determination. And so if you have folks from both classes, it fails that standard. So what they're arguing is that not that the analysis was successful or failed, they as in Ames. Ames is saying that the analysis is unconstitutional, that there should not even be an additional analysis. And both courts are saying this analysis is required for us to get to that point. Why? Because there is no history of the minorities, a group discriminating against a majority group. The last thing is they need statistics. Show me stats, show me numbers, show me receipts where they've done this over and over and over again, where you can point to, hey, 30, 40, 50 years. And I might add, this standard has been there since the 80s. 1981 is the case where the first Court of Appeals said, this is the background circumstance standard that we should use. So that's 40 years of precedent. I'd like to see if the court would overturn that, but we do have a history of them overturning precedent in this most recent Supreme Court.
We're almost out of time, Khalif. Is this going to be dead on arrival? I mean, it's failed up to this point.
I wouldn't say dead on arrival. I think those other courts got the analysis right. Okay. I think this court is at least open, this Supreme Court is open to an argument. They're
Okay.
open to walking through the standard. I don't think it's a landslide, but I do think the majority goes against Ames because precedent, case law after case law, supports ruling against it.
Yeah. All right, Khalif, thank you very much. A couple of other topics coming up here in the next hour with Khalif as well.